Before we begin, a quick and important disclaimer. The historical data, legal frameworks, and case studies discussed in this multi-part masterclass are provided strictly for educational and entertainment purposes. This content does not constitute professional legal advice, financial counsel, or family law expertise. Marital laws vary significantly by state jurisdiction and have evolved dramatically over the course of the last century. Viewers should always conduct their own due diligence and consult with a licensed, qualified attorney or professional regarding their specific personal circumstances, legal rights, and financial security before making any decisions related to marriage, cohabitation, separation, or asset division. Imagine stepping into a dimly lit hotel room in Manhattan in the year 1934. A professional photographer stands poised by the door, camera ready, while a private investigator prepares to take notes. On the bed sits a husband in his undershirt alongside a young woman he hired just hours ago from a local casting agency. They are not having an affair. In fact, they barely know each other's names. Suddenly, the door flashes with light as a photograph is taken, capturing a perfectly staged scene of infidelity. This staged photo will become Exhibit A in a New York courtroom the following week. This bizarre, high-stakes charade was known as the collusive divorce mill, and for decades, it was one of the only ways an unhappily married couple in America's economic capital could legally sever their marital bonds. Because New York law at the time recognized absolutely no grounds for divorce other than proven adultery, couples who mutually wished to separate were forced by the state to fabricate criminal fraud, hire professional correspondents, and commit systematic perjury under oath just to achieve legal freedom. If the judge suspected for even a single moment that both the husband and wife actually wanted the divorce and had agreed to stage the scene, the legal doctrine of recrimination or collusion would kick in. The judge would immediately throw the case out, and the couple would remain legally chained together for life. This absurd reality created an entire parallel underground economy of private investigators, staged hotel actors, and corrupt legal practitioners specializing in fabricated sin. For those who could afford to avoid this public humiliation, the only alternative was a cross-country train ride to Reno, Nevada. In what became known as the migratory divorce phenomenon, wealthy Americans flooded Nevada to establish a temporary 6-week residency in specialized divorce ranches, taking advantage of the state's uniquely lenient laws to secure a clean break before returning home. The American legal system had effectively turned the ending of a marriage into a luxury commodity or a criminal conspiracy, creating a massive societal pressure cooker that was bound to explode. To truly understand how we transition from this era of institutional containment to the modern hyper-individualized landscape of today, we must look at the data and the historical trends that reshape the American household. Over the last century, the institution of American marriage underwent a total philosophical reconstruction. In the early decades of the 20th century, marriage was viewed primarily through an institutional lens. It was a contract rooted in economic survival, gender-specific specialization, community stability, and the structured raising of children. Subjective emotional satisfaction, while desirable, was considered secondary to the fulfillment of duty, obligation, and familial sacrifice. However, as the nation shifted from an agrarian economy to an industrial and post-war consumer powerhouse, societal values began to transform. The turning point arrived with the profound cultural and legal upheavals of the late 1960s. In 1969, California Governor Ronald Reagan signed the nation's first true no-fault divorce bill, the Family Law Act, which officially took effect in 1970. Reagan, who had himself gone through a painful fault-based divorce from his first wife under accusations of mental cruelty, intended the bill to eliminate the pervasive perjury and animosity built into the adversarial system. Instead of requiring one party to prove a grievous wrong like adultery, physical cruelty, or abandonment, couples could now cite irreconcilable differences or an irremediable breakdown of the marriage. What followed was a legal domino effect. Within 15 years, virtually every state in the Union passed its own version of no-fault legislation. This legal transformation unlocked a massive, suppressed demand for marital exit, resulting in what historians call the divorce revolution. The statistical reality of this shift is staggering. Between 1960 and 1980, the United States divorce rate more than doubled, climbing from 9.2 divorces per 1,000 married women to an all-time peak of 22.6 divorces per 1,000 married women. While less than 20% of couples who married in 1950 saw their marriages dissolve, approximately 50% of couples who tied the knot in 1970 eventually entered a courtroom to end their unions. This was not merely a change in legal paperwork. It was a total psychological revolution. The traditional institutional model of marriage was systematically replaced by the soulmate model of marriage, driven by a cultural philosophy of expressive individualism. Under this new framework, an individual's primary moral obligation shifted away from sacrificing for the family unit and toward maximizing personal happiness, self-actualization, and emotional fulfillment. If a marriage no longer served a person's inner growth, staying became viewed not as a virtue, but as a failure to honor oneself. At the exact same time, the economic landscape for women was undergoing a parallel evolution that provided the practical means to match this newfound psychological freedom. Prior to the mid-1970s, an unhappily married woman faced immense structural financial barriers if she wished to leave an abusive or unfulfilling relationship. It was not until the passage of the Federal Equal Credit Opportunity Act of 1974 that financial institutions were legally banned from discriminating against applicants based on sex or marital status. Before this landmark legislation, a woman often could not even open a basic bank account, obtain a credit card, or secure a mortgage without the explicit signature of her husband or a male relative. The acquisition of financial autonomy, combined with surging female workforce participation throughout the 1970s and 1980s, fundamentally changed the risk-reward calculus of staying in a broken marriage. Legal freedom meant very little without the economic capacity to survive independently, and once women secured both, the structural dynamics of American domestic life changed forever. For the modern U.S. audience, understanding this intricate century-long trajectory is not just an exercise in historical trivia. It is an absolute necessity for navigating the legal, financial, and relational realities of today. Every single modern systemic mechanism we encounter in relationships today, from the specific wording of a prenuptial agreement to the complex algebraic math used by judges to calculate equitable asset distribution, rehabilitative spousal support, and joint child custody frameworks, is built directly on the architectural debris of this historical evolution. Today, the societal divorce journey is experiencing yet another massive paradigm shift. While overall divorce rates among younger generations have actually stabilized or decreased due to delayed marriage and increased cohabitation, a completely different trend is emerging at the other end of the demographic spectrum. The phenomenon of gray divorce, couples over the age of 50 splitting after decades of marriage, has surged dramatically over the last 20 years. This presents modern Americans with a highly complex set of contemporary financial and legal hurdles, where the dissolution of a long-term marriage is no longer about child custody battles, but about the intricate splitting of mature 401ks, pension plans, social security benefits, and multi-generational estate planning. By deep diving into this 10-part masterclass, you will dismantle the persistent cultural myths surrounding the American split, moving past the emotional rhetoric to analyze the cold, hard operational realities of family law and socioeconomics. You will learn exactly how states transition from punishing wrongdoing to balancing economic partnerships, how the concept of alimony evolved from a lifetime pension into a temporary bridge toward self-sufficiency, and how modern couples use strategic planning to protect their assets and their children. Whether you are looking to understand the historical forces that shaped your own family background, seeking to comprehend the legal mechanics governing modern partnerships, or looking to protect your financial future in an unpredictable legal landscape, analyzing this century of change provides the definitive roadmap to modern relationship literacy. In the upcoming segments of this series, we will break down the exact mechanics of these shifts decade by decade, examining real-world case studies, shifting property laws, and the hidden economic forces that continue to dictate how Americans love, marry, and part ways. To understand the modern framework, we have to look closely at the architecture of the early 20th century, an era dominated by the rigid doctrine of matrimonial fault. This legal philosophy treated marriage as an indissoluble sacrament or a permanent state-sanctioned contract that could only be broken if one party committed an egregious moral and legal violation against the other. The courts operated not as facilitators of personal transitions, but as moral arbiters. Under this system, a divorce could never be granted by mutual consent. In fact, if a husband and wife both agreed that their marriage was dead and walked into a courtroom together to request a dissolution, the law viewed this mutual agreement as an illegal conspiracy called collusion. The legal system required an adversarial battleground where there had to be a clearly defined innocent victim and a clearly defined guilty perpetrator. To secure a legal separation, the plaintiff had to provide absolute proof of specific statutory grounds, which most commonly included adultery, physical cruelty, willful desertion, or long-term imprisonment. If you could not prove one of these specific sins in a court of law, you simply remained married, regardless of how much misery, hatred, or emotional detachment existed within the household. This system was reinforced by a set of complex legal defenses, designed explicitly to prevent marriages from ending. Defense attorneys routinely used the doctrine of recrimination, which dictated that if both spouses were guilty of a marital fault, neither could be granted a divorce. If a husband sued his wife for desertion, but the wife could prove the husband had committed adultery, the judge would rule that both parties had unclean hands. The potential outcomes of this rule were devastating. The court would deny the divorce entirely, forcing two people who actively detested each other to remain legally bound together. Let us look at a concrete historical scenario to see how this played out in daily life. Imagine a woman named Helen living in Ohio in the mid-20th century. Helen is trapped in a deeply unhappy, emotionally cold marriage. Her husband does not beat her, and he does not cheat on her. But the relationship has completely deteriorated into silent hostility and emotional isolation. From our vantage point today in the year 2026, we view irreconcilable differences as a standard, everyday legal reality. But for Helen, that concept does not exist. If she packs her bags and leaves the house to escape the toxic environment, her husband can immediately sue her for willful desertion. If Helen is found at fault for desertion, historical trends of the era show that she would be stripped of any right to financial support, potentially leaving her completely destitute in a society where career opportunities for women are severely restricted. To secure a divorce on her own terms, Helen would have to prove extreme cruelty. In the legal landscape of the time, this did not mean a husband was rude or emotionally distant. To satisfy the court, extreme cruelty required documented evidence of severe physical violence that endangered her life, or public humiliation so profound it caused documented physical illness. Because the legal bar was set so high, an entire parallel industry of deception and espionage emerged across the United States. Wealthy spouses routinely hired private investigators to track partners, wiretap home telephones, and break into hotel rooms to secure photographic evidence of infidelity, which was often staged. For middle-class and working-class families who could not afford private detectives, the options were grim. Many couples resorted to abandonment, where a husband would simply disappear across state lines to start a new life under an assumed name, leaving the wife and children to fend for themselves. This created a massive socioeconomic crisis that burdened local charities and state relief programs, as thousands of women were left in a legal limbo where they were neither fully married nor legally free to remarry or claim state support. For those who possessed the financial means to bypass the local courtroom charade, the city of Reno, Nevada, became the ultimate national escape hatch. Let us examine the exact mechanics of the migratory divorce industry, which serves as a prime historical case study of economic supply meeting legal demand. In 1931, during the depths of the Great Depression, the state of Nevada realized it could generate massive internal revenue by transforming itself into a legal haven. The state legislature lowered its residency requirement to just 6 weeks and expanded its legal grounds for divorce to include vague terms like mental cruelty. This legislative shift triggered a massive economic boom. Wealthy Easterners, Hollywood celebrities, and affluent professionals from across the country flooded into Nevada. They stayed in specialized divorce ranches, spending 42 days riding horses, gambling in casinos, and injecting millions of dollars into the local economy. Once the 6 weeks passed, they appeared before a local Nevada judge, offered brief, scripted testimony about their spouse's mental cruelty, received their decree, and boarded the next train back home. By the 1940s, Reno was processing upwards of 10,000 divorces annually, turning marital dissolution into a highly profitable tourism industry. This migratory phenomenon created a profound constitutional crisis in American law. Under the full faith and credit clause of the United States Constitution, states are generally required to recognize the public acts, records, and judicial proceedings of every other state. However, conservative judges in states like New York and North Carolina fiercely resisted Nevada's lax standards. Courts in those states occasionally arrested citizens who returned from Reno with a Nevada decree, charging them with bigamy and cohabitation out of wedlock if they attempted to remarry, ruling that the 6-week Nevada residency was a legal fiction designed solely to evade local laws. The financial consequences of this fault-based system were explicitly punitive and deeply gendered. Property division during this era followed the title state system. This meant that upon divorce, property belonged entirely to the person whose name was on the deed or the bank account. Because the vast majority of married women during the early and mid-20th century worked exclusively inside the home as homemakers, they held no independent income and no property titles. The law did not recognize a wife's domestic labor, child-rearing, or homemaking as a financial contribution to the acquisition of marital wealth. As a result, a divorcing wife was completely dependent on the court's award of alimony to survive. Alimony was not calculated based on modern ideas of economic rehabilitation or self-sufficiency. It was used as an explicit economic weapon to reward virtue and punish sin. If a husband was found guilty of extreme cruelty or adultery, the court would often order him to pay permanent alimony that severely restricted his financial future, functioning as a lifelong financial penalty. Conversely, if a wife was found guilty of a marital fault like infidelity, she was routinely denied any alimony whatsoever, regardless of how many decades she had contributed to the household. This high-stakes legal gambling turned every single divorce proceeding into an absolute scorched earth war. Reputations were publicly destroyed in local newspapers, family secrets were dragged into open court records, and children were routinely used as bargaining chips to force financial settlements. The legal system's insistence on proving sin created a culture of systemic hypocrisy, where judges, lawyers, and clients all silently participated in a shared theater of fabricated evidence and exaggerated claims just to allow miserable couples to achieve legal freedom. By the late 1950s, the gap between rigid legal statutes and the actual lived reality of the American public had widened into a cavernous void. The post-World War II era saw an unprecedented surge in marriage rates and the birth of the baby boom generation, which initially masked the underlying marital instability. Suburbs expanded, and the idealized nuclear family became the dominant cultural narrative. Yet, beneath the pristine surface of suburban domesticity, thousands of couples were profoundly incompatible, trapped in relationships that offered no legal or socially acceptable exit. The institutional resistance to change was massive, driven by a deep societal fear that if you made the exit journey easy, the very fabric of the American family would disintegrate overnight. What the traditional establishment did not realize was that a massive demographic, cultural, and legal earthquake was quietly brewing right beneath their feet. An unexpected convergence of legal scholars, social activists, and a future United States president was about to launch a legislative assault that would completely dismantle centuries of family law in a matter of months. In the next part of this masterclass, we will look at the secret history behind the birth of no-fault divorce, the hidden economic fallout that hit women in the immediate aftermath of the revolution, and how the sudden elimination of fault fundamentally altered the financial value of a homemaker overnight. To fully comprehend the immediate aftermath of this legal earthquake, we must look at how the elimination of fault transformed the structural bargaining power within American households. Before the 1970 revolution, the spouse who wished to preserve the marriage, or the spouse who was legally innocent, held an immense amount of leverage. If a husband wanted to leave his wife to start a life with someone else, but he had no legal grounds to sue her, the wife held an absolute veto power. She could use this veto power to negotiate a highly favorable financial settlement, securing the family home, a significant portion of his income, and robust child support arrangements in exchange for granting him his freedom. The introduction of unilateral no-fault divorce completely inverted this dynamic overnight. For the first time in American history, a marriage could be dissolved by the desire of just one partner, and the other partner was entirely powerless to stop it. The legal system effectively removed the requirement of mutual consent or proven misconduct, treating the marital contract as an agreement that could be terminated at will by either party. Let us look at an explicit step-by-step scenario to see how this legislative shift played out in real time for thousands of families across the United States. Imagine a woman named Linda living in a suburb of Chicago. Linda married her husband in 1952. For 2 decades, she operated strictly within the mid-century societal script. She dropped out of college to support her husband while he climbed the corporate ladder, managed the household budget, maintained the property, and raised their 3 children. She had no independent income, no retirement accounts in her name, and a 20-year gap on her resume. If her husband decided to end the marriage in 1965, he faced massive social stigma and severe legal and financial penalties. The court would have required him to provide permanent financial support to Linda to maintain her standard of living, punishing his desire to exit the union. Now imagine if that exact same scenario unfolded just a few years later, after the state passed its no-fault legislation. The husband could walk into a family court, file a petition citing irreconcilable differences, and move forward with the dissolution without Linda's consent. When Linda appeared before the judge, she quickly discovered that the legal system had adopted a new philosophy of formal equality. The courts began to operate under the assumption that men and women were now completely equal economic actors in the marketplace. While this concept aligned with the broader goals of the feminist movement of the era, the practical application in family courtrooms often resulted in severe economic vulnerability for traditional homemakers. The judge looked at Linda and her husband as two autonomous individuals who simply needed to divide their assets and move on with their separate lives. The court did not look at the hidden systemic trade-offs that had occurred over the 20-year marriage. Linda's husband possessed a highly valuable, appreciating asset that did not appear on any traditional corporate balance sheet: his career, his professional network, his advanced skills, and his enhanced earning capacity. Linda, on the other hand, possessed a rapidly depreciating asset: 20 years of lost career development, obsolete skills, and an inability to re-enter the competitive job market at a comparable level. Historical trends and case studies from this era reveal a stark, nationwide pattern of economic divergence. Sociological studies conducted throughout the late 1970s and 1980s highlighted a massive unintended consequence of the no-fault revolution. In the immediate years following a divorce under the new system, the standard of living for divorced women and their children suffered an immediate and substantial decline, while the standard of living for divorced men frequently experienced a noticeable increase. This occurred because judges, eager to implement the new philosophy of self-sufficiency, drastically cut back on both the duration and the amount of spousal support awards. The traditional concept of permanent alimony was systematically replaced by a new legal mechanism known as rehabilitative alimony. This support was no longer viewed as a lifelong pension or a reward for a wife's virtue. Instead, rehabilitative alimony was designed as a strictly temporary financial bridge, typically lasting only 2 to 5 years, intended solely to cover the immediate cost of a short-term training program, secretarial school, or community college degree. The explicit expectation was that the former homemaker would quickly transition into full self-sufficiency, regardless of her age, her health, or the competitive realities of the labor market. The potential outcomes for women like Linda were often financially devastating. The math simply did not work. A 45-year-old woman entering the workforce for the first time in 2 decades could not secure a job that paid anywhere near the salary of a corporate executive with 25 years of continuous experience. Yet, the law treated them as if they were starting from the exact same baseline. Furthermore, the division of tangible property under the new no-fault frameworks created its own set of distinct challenges. In states that adopted a strict 50-50 community property split, or an equitable distribution model without considering fault, the primary asset owned by the average American family was the suburban home. Because there were rarely enough liquid cash accounts or investment portfolios to offset the value of the house, the family court judge frequently had no choice but to order the immediate sale of the marital residence so the proceeds could be split evenly down the middle. This meant that a mother who had secured primary physical custody of the children was suddenly forced to sell the home, uproot her children from their schools, and move into a smaller rental apartment in an entirely different neighborhood, all during a period of profound emotional upheaval. The equity realized from the sale of a suburban home, when split in half, was rarely enough to allow a single mother to purchase a new property in a comparable area, effectively accelerating the downward economic mobility of the fractured family unit. By treating marriage as a short-term commercial partnership rather than a lifelong socioeconomic covenant, the early iterations of the no-fault system inadvertently penalized the very individuals who had invested the most heavily in the traditional family structure. The legal system had successfully removed the toxic perjury and the ugly private detective games of the fault era, but it had replaced them with an institutional blindness to the structural economic realities of gender and domestic labor. As the United States moved out of the 1970s and entered the highly materialistic, fast-paced corporate landscape of the 1980s, the scale of this domestic economic crisis became impossible for state legislatures to ignore. The sheer volume of single mothers sliding into systemic poverty, combined with an unprecedented epidemic of non-payment of child support by non-custodial parents, forced a massive institutional reckoning. The federal government was about to step into the arena, fundamentally changing how child support was calculated, tracked, and enforced across state lines. At the exact same time, a massive psychological and legal war was brewing over a completely different aspect of the split: the custody of the children. For decades, courts had operated under a tender years doctrine that automatically favored mothers, But a new movement was about to challenge this convention, introducing the complex and fiercely contested era of joint custody. In the next part of this masterclass, we will examine the high-stakes legislative battles that created the modern child support enforcement complex, the weaponization of custody arrangements in the 1980s, and how the legal system attempted to correct the severe financial imbalances it had created. To understand the scale of the crisis that triggered the modern child support enforcement complex, one must look at the macroeconomic reality of the early 1980s. The sudden spike in marital dissolutions throughout the previous decade had left a massive structural deficit in its wake. Across the United States, hundreds of thousands of single-mother households were slipping into poverty, and state welfare rolls, specifically the Aid to Families with Dependent Children program, were stretching to a breaking point. The fundamental flaw of the early no-fault system was its complete reliance on individual judicial discretion to set child support amounts. A judge in one county might order a non-custodial father to pay a substantial portion of his income, while a judge in a neighboring county might order a nominal fee that failed to cover the baseline cost of groceries. Even worse, once an order was issued, states possessed virtually no centralized infrastructure to track compliance or penalize non-payment. Historical trends from this specific era reveal that less than half of all custodial parents who were awarded child support received the full amount due, and a staggering percentage received absolutely nothing at all. This systemic failure gave rise to the cultural archetype of the deadbeat dad, a phenomenon that captured national media attention and forced the federal government to intervene directly in family law, a domain traditionally reserved exclusively for individual state sovereignty. The turning point arrived with the passage of the Federal Child Support Enforcement Amendments of 1984, followed quickly by the sweeping Family Support Act of 1988. These bipartisan pieces of legislation fundamentally transformed child support from a private domestic dispute into a highly automated, federally mandated economic enforcement system. The federal government forced every single state to adopt explicit, mathematical numerical guidelines to calculate child support, eliminating arbitrary judicial discretion. Furthermore, these acts mandated the implementation of immediate wage withholding. Imagine the operational shift this caused. If a court ordered a non-custodial parent to pay support, that obligation was automatically deducted from their paycheck by their employer and routed through a state disbursement unit before the employee ever saw the funds. To ensure compliance, the government established the Federal Parent Locator Service, granting state enforcement agencies unprecedented access to Social Security databases, Internal Revenue Service records, and State Department data to track down individuals who cross state lines to evade their obligations. To understand how this math functions in practice today, we must look at the two primary algorithmic models developed during this period that continue to dictate financial realities across the United States. The first is the percentage of income model, which is elegantly simple but structurally rigid. In this framework, the state dictates a fixed percentage of the non-custodial parent's gross or net income based solely on the number of children involved, completely independent of the custodial parent's earnings. For example, a state might mandate that a non-custodial parent pay exactly 20% of their net income for one child, 28% for two children, and 32% for three children. The second, more prevalent framework is the income shares model, which operates on a more complex socio-economic philosophy. This model operates on the assumption that a child should receive the exact same proportion of parental income that they would have received if the parents had remained married and lived in a single household. To calculate this, the court combines the monthly net incomes of both parents to find their basic combined support obligation, using a state-vetted economic statistical chart. Once that baseline number is established, the total financial obligation is divided proportionally between the parents based on their respective percentages of the total combined income. Let us look at a precise case study to see how this works step by step. Imagine a father named Mark and a mother named Susan navigating a family court proceeding. Mark earns $6,000 a month, and Susan earns $4,000 a month, bringing their combined monthly income to $10,000. The state's economic table dictates that for a combined income of $10,000, the basic baseline cost of raising one child is $1,500 a month. Because Mark contributes 60% of the total income, he is responsible for 60% of that $1,500 baseline, which equals $900. Because Susan contributes 40% of the income, she is responsible for $600. If Susan is the primary custodial parent with whom the child resides the vast majority of the time, Mark is ordered to pay his $900 share directly to Susan every single month. While this mathematical automation brought predictability and financial stabilization to millions of households, it collided directly with a parallel revolution occurring in the realm of child custody. Historically, American courts had operated under the tender years doctrine, a legal presumption originating in the 19th century which dictated that during their tender years, children belonged inherently with their mothers due to a biological and emotional maternal bond. Under this old framework, unless a mother was proven to be profoundly unfit through severe neglect or moral depravity, she was automatically granted sole physical and legal custody, while the father was relegated to alternating weekend visitation rights. By the mid-1980s, this gender-biased paradigm was facing fierce resistance from both legal scholars and newly organized fathers' rights advocacy groups. Critics argued that the automatic maternal presumption violated equal protection principles and ignored the shifting realities of a society where women were entering the workforce in record numbers and fathers were increasingly participating in active day-to-day parenting. Consequently, states systematically dismantled the tender years doctrine, replacing it with the gender-neutral best interests of the child standard. This shift opened the door for the rapid rise of joint custody arrangements, fundamentally altering the parenting dynamic after a split. The introduction of joint custody split the concept into two distinct legal categories: joint legal custody and joint physical custody. Joint legal custody meant that regardless of where the child slept at night, both parents retained equal decision-making authority over the major, life-altering aspects of the child's upbringing, including their healthcare choices, religious training, and educational enrollment. Joint physical custody, however, required the child to divide their actual living time between both parental households on a relatively equal basis. While joint physical custody was envisioned as an idealistic solution to maintain strong bonds with both parents, its practical intersection with the newly established mathematical child support guidelines created an intensely adversarial environment. Because the income shares model factors the exact number of overnight stays a child spends with each parent directly into the final child support formula, parenting time was suddenly transformed into a direct financial commodity. If Mark could secure enough overnight stays in the custody schedule to cross a specific statutory threshold, often 128 overnights a year, the law viewed the arrangement as a shared parenting situation. This crossing of the threshold triggers a dramatic reduction in the monthly child support payment he is required to pay Susan. Consequently, custody mediation sessions and courtroom battles throughout the late 1980s and into the 1990s became highly charged financial chess matches. Parents found themselves aggressively litigating over a single extra night a week, not necessarily out of parental desire, but because that single night represented a swing of hundreds of dollars in monthly support payments. The legal system had inadvertently created a structure where emotional parenting decisions were inextricably linked to precise monthly cash flows. This weaponization of custody arrangements added a layer of systemic friction to the societal divorce journey, transforming the dissolution process into a multi-front war of financial attrition and chronological accounting. As couples realized that every single decision made in the immediate aftermath of a separation would dictate their economic baseline for decades, the demand for preventative legal measures began to skyrocket. The traditional boundaries of marital property were about to be tested like never before. Corporations were expanding, the stock market was surging, and a new generation of high-earning professionals was about to enter the matrimonial arena with a desire to insulate their personal wealth from the reach of the family court system. In the next part of this masterclass, we will examine the rise of the modern prenuptial agreement, how the legal definition of marital property expanded to include corporate bonuses, stock options, and professional degrees, and how the wealthy began to deploy sophisticated legal mechanisms to guard their estates before ever walking down the aisle. To understand how asset insulation became a multi-billion-dollar industry in the United States, we have to trace the dramatic expansion of what family courts actually classified as marital property during the late 20th century. In the early days of no-fault divorce, asset division was relatively straightforward, focusing almost entirely on tangible assets that could be easily valued and sold, such as the family home, the family car, bank accounts, and perhaps physical business infrastructure. However, as the American economy shifted toward a white-collar, corporate-driven knowledge economy, wealth became increasingly intangible, complex, and deferred. Imagine a corporate executive named David navigating a high-stakes divorce in the late 1980s. David does not just receive a straightforward bi-weekly paycheck. His compensation package is a sophisticated web of financial instruments designed to minimize tax liabilities and bind his long-term performance to the company. His package includes unvested stock options, deferred compensation plans, restricted stock units, and executive pension schemes that will not pay out for another 15 years. Historical trends show that during this era, family courts had to completely reinvent their economic frameworks to handle these intangible assets. Non-employee spouses began to argue with great success that since these executive perks were earned during the marriage, they constituted marital property subject to an equitable split, regardless of whether the funds were currently accessible. This legal evolution forced courts to develop highly complex actuarial formulas to determine the marital portion of unvested assets. Judges routinely deployed the Coover formula or the Woodward time rule, which calculated a specific fraction, the number of months the spouse worked at the company while married divided by the total number of months of employment required for the stock options to vest. This fraction was then multiplied by the total value of the options to determine the precise marital share. If David was granted stock options that required 5 years of service to vest, and he was married for 3 of those 5 years before separating, 60% of those options were suddenly classified as marital property, throwing a massive wrench into executive financial planning. But the battle over intangible wealth reached its absolute peak when courts were asked to value something even more abstract: a professional license. Let us analyze a landmark historical case study that permanently altered the landscape of American family law. The 1985 New York case of O'Brien versus O'Brien. Michael O'Brien was a medical student who married his wife Loretta before he had even obtained his medical degree. Throughout their marriage, Loretta worked as a schoolteacher, contributing her entire salary to pay for the couple's living expenses, housing, and Michael's medical school tuition. She sacrificed her own career advancement and managed the household entirely so that Michael could focus exclusively on his rigorous medical training. Just 2 months after Michael finally obtained his license to practice medicine, he filed for divorce. Under traditional property laws, Michael walked away with his medical degree, which represented immense future earning capacity, while Loretta walked away with nothing but a history of financial sacrifice, as there were virtually no tangible assets to divide. The New York Court of Appeals issued a revolutionary ruling that sent shockwaves through the legal community. The court determined that a professional license acquired during a marriage is a marital asset subject to equitable distribution. To implement this ruling, family courts had to develop an entirely new methodology for calculating the enhanced earning capacity of a professional spouse. Forensic accountants were hired to project exactly how much a general medical practitioner would earn over a working lifetime compared to a college graduate without a medical degree. They took this projected multimillion-dollar differential, adjusted it for inflation, applied a discount rate to find its net present value, and then awarded the non-student spouse a significant percentage of that abstract value, payable over a series of years. Imagine if a young professional today in 2026 faced this reality without prior planning. The potential outcomes of these expanding legal definitions meant that getting married without a clear financial contract was essentially signing a blank check to a future court system. This specific risk factor drove the rapid evolution and widespread adoption of the prenuptial agreement. Historically, American courts viewed prenuptial agreements with extreme suspicion. Throughout the 19th and early 20th centuries, prenuptial contracts were routinely struck down by judges who ruled they were contrary to public policy because they allegedly facilitated and encouraged the dissolution of marriages. The law operated under the assumption that if a couple planned for a divorce before the wedding took place, they were actively undermining the permanent nature of the marital sacrament. The paradigm completely shifted as the divorce rate skyrocketed. In 1983, the National Conference of Commissioners on Uniform State Laws drafted the Uniform Premarital Agreement Act, which was subsequently adopted by the vast majority of U.S. states. This statutory framework recognized that prenuptial agreements, far from destroying marriages, actually provided essential economic stability and predictability. The law shifted from prohibiting these agreements to highly regulating their execution. To be deemed legally enforceable today, a prenuptial agreement must clear a series of rigorous statutory hurdles designed to ensure fundamental fairness. First, there must be a full, honest, and meticulous financial disclosure by both parties. If a wealthy individual attempts to hide a single offshore bank account, a hidden real estate holding, or a corporate stake from their future spouse during negotiations, the entire agreement can be completely invalidated by a judge years later due to fraud. Second, the agreement must be executed completely voluntarily. If a bride or groom is presented with a thick, complex prenuptial contract just hours before the wedding ceremony takes place, with the guests already arriving and the catering paid for, A modern court will likely rule that the contract was signed under extreme duress and throw it out. Third, both parties must typically be represented by independent legal counsel to ensure that each individual fully understands the precise rights they are waiving. As prenuptial agreements became standardized for the wealthy, the ultra-affluent began to look for even more sophisticated methods of asset insulation that did not require the consent of a future partner. This led to the rise of the Domestic Asset Protection Trust and the strategic exploitation of separate property rules. Under standard U.S. family law, property owned by an individual prior to the marriage is classified as separate property and is generally protected from division. However, the operational reality of a long-term marriage often makes preserving this separate status nearly impossible due to the legal doctrine of transmutation and commingling. Imagine a scenario where an individual enters a marriage with a separate investment account worth $500,000. Over a decade of marriage, they occasionally deposit marital earnings into that account, or they use funds from that account to pay for the mortgage on the shared family home. Through these actions, the separate property has become thoroughly commingling with marital assets, causing it to lose its protected status entirely. To bypass this vulnerability, sophisticated estate planners began utilizing irrevocable trusts established in specific states like Alaska, Delaware, or Nevada, which allowed individuals to place their premarital wealth into a separate legal entity that sits entirely outside the jurisdiction of a family court judge. The societal divorce journey had officially transformed from a moral and religious evaluation into a highly sophisticated, financially weaponized chess match where the rules of corporate accounting, contract law, and trust management took absolute precedence over marital sentiment. Every single emotional breakdown within a household was now accompanied by an incredibly technical audit of intellectual property, business valuations, and appreciation tracking. Yet, as the legal and financial mechanisms became increasingly professionalized and corporate-centric, the human and emotional cost of these prolonged adversarial battles began to take an immense, undeniable toll on the fabric of American society. The relentless focus on maximizing financial position was creating a parallel crisis of psychological trauma, particularly for the children caught in the crossfire of these high-stakes multi-year litigations. The traditional adversarial courtroom model, which pitted spouse against spouse in an expensive public war of attrition, was about to face a massive internal rebellion from a new generation of legal reformers, psychologists, and couples who demanded a more humane way to part ways. In the next part of this masterclass, we will look at the rise of the collaborative divorce movement, the emergence of mandatory mediation programs, and how the legal system attempted to pivot away from scorched-earth courtroom battles towards psychological stabilization and dispute resolution. The traditional family law paradigm was built entirely on an adversarial framework inherited from English common law, a system designed to resolve disputes between two conflicting parties by pitching them against each other in a courtroom battleground. In criminal or standard civil litigation, this model serves a clear purpose, but when applied to the delicate, deeply interconnected web of a fracturing family, the adversarial system frequently acted as an accelerant to emotional and financial ruin. By its very nature, litigation required each spouse to hire a legal champion whose professional obligation was to zealously advocate for their client's individual position. This dynamic naturally incentivized the excavation of every past mistake, the exaggeration of every domestic grievance, and the weaponization of personal vulnerabilities through public depositions, interrogatories, and aggressive cross-examinations. By the late 1980s and early 1990s, the systemic fallout of this scorched earth approach was undeniable. A standard contested divorce could drag on for 2 to 3 years, consuming a massive portion of a family's net worth in billable hours, court fees, and forensic valuation costs. Even worse, the psychological trauma inflicted upon the children of these litigating couples was profound and long-lasting, as they were routinely caught in the crossfire of parental hostility. Legal scholars, family therapists, and progressive jurists began to realize that a courtroom, presided over by a judge who had only a few hours to review the intricate details of a family's entire life, was the absolute worst place to resolve complex domestic reconfigurations. This realization ignited a massive internal rebellion within the legal profession, giving birth to the modern alternative dispute resolution movement. The first major institutional shift away from the courtroom occurred with the widespread implementation of mandatory divorce mediation programs. State legislatures began rewriting family court rules to dictate that before a couple could ever schedule a trial date to argue about asset division or child custody, They were legally required to sit down in a room with a neutral third-party mediator to attempt to resolve their differences outside the adversarial arena. Unlike a judge, a mediator possesses zero authority to impose a decision or force a settlement upon the parties. Instead, the mediator functions as a highly skilled facilitator, trained in negotiation theory, conflict resolution, and the specific nuances of family law. Let us look at the exact step-by-step operational mechanics of how mediation transformed the societal divorce journey. The process begins with the voluntary or court-ordered selection of a qualified mediator, who is often an experienced family law attorney or a licensed mental health professional specializing in family dynamics. The mediation sessions take place in a private office setting, completely shielded from the public eye. This privacy is reinforced by strict confidentiality laws. Absolutely nothing said, offered, or conceded during a mediation session can be admitted as evidence in a subsequent court trial if the negotiation fails. The mediator utilizes two primary structural techniques: joint sessions, where both parties and their attorney sit at the same table to discuss issues directly, and caucusing, where the mediator separates the spouses into different rooms and shuttles back and forth between them. Caucusing is incredibly effective in high-tension scenarios, as it allows the mediator to de-escalate emotional triggers, challenge unrealistic expectations privately, and explore creative compromises without the fear of immediate defensive reactions from the other side. If the mediation succeeds, the mediator drafts a comprehensive document known as a Memorandum of Understanding, which is then translated into a formal, binding marital settlement agreement and submitted to a judge for a routine, non-adversarial signature. While mediation introduced a vital layer of diplomacy to the split, a visionary family law attorney in Minneapolis named Stuart Webb realized in 1990 that the system needed an even more radical transformation. Webb observed that as long as attorneys retained the option to threaten litigation during a negotiation, the shadow of the courtroom would always corrupt the collaborative potential of the process. To solve this, Webb created an entirely new legal framework known as collaborative divorce. The absolute crown jewel and foundational engine of the collaborative model is the disqualification agreement. When a couple enters the collaborative process, both spouses and their respective collaborative attorneys sign a legally binding participation agreement stating that they are entering into a completely transparent, non-litigation track. The contract explicitly mandates that if either party walks away from the negotiation table to file a lawsuit in family court, both collaborative attorneys are immediately disqualified from representing them any further. This disqualification clause completely aligns the financial and professional incentives of everyone in the room. In traditional litigation, an attorney can theoretically make more money if the conflict escalates and heads to trial. In a collaborative framework, if the process fails, the attorneys lose their clients and all future billable hours on that case. Consequently, the lawyers stop acting as gladiators and start operating as problem solvers, working alongside their clients to find mutually beneficial solutions. Furthermore, collaborative divorce evolved from a simple legal negotiation into a multidisciplinary team approach. Instead of relying solely on two opposing lawyers, the collaborative process integrates neutral experts directly into the structure. A typical collaborative team includes a neutral financial professional, who gathers all tax returns, bank statements, and retirement account data to create objective financial projections for both parties. It also includes a family dynamics coach or mental health professional, who helps the couple navigate emotional triggers and communication breakdowns. If children are involved, a neutral child specialist is brought in to meet with the kids and advocate strictly for their psychological and developmental needs, helping the parents construct a customized parenting plan. To see how these two completely divergent tracks operate in the current landscape of 2026, let us analyze an imaginative scenario involving a couple named John and Sarah. John is a senior software architect and Sarah is a director of corporate marketing. They have been married for 15 years, have 2 children, and own a home along with various stock options and retirement accounts. If John and Sarah follow track A, the traditional litigation model, their journey begins with a formal process of discovery. This involves serving subpoenas on financial institutions, conducting lengthy depositions where they are grilled by opposing counsel, and filing motion after motion regarding temporary support and visitation schedules. Historical trends reveal that within 12 months, John and Sarah will likely have spent upwards of $60,000 combined in legal fees. Their personal text messages and emails will be attached to public court filings for anyone to read. By the time they finally stand before a judge for a trial, their relationship as co-parents will be completely destroyed, and the judge will issue an arbitrary ruling that leaves both parties deeply dissatisfied. Now, imagine if John and Sarah choose track B, the collaborative divorce framework. They sit down in a private conference room with their collaborative lawyers, a neutral financial analyst, and a family coach. The neutral financial professional organizes their assets into a clear spreadsheet, offering various potential outcomes for dividing the house in equity based on tax implications. The family coach helps John and Sarah manage their anger, guiding them to design a joint parenting schedule that preserves stability for their children. The entire process takes 4 months, costs a fraction of a trial, remains entirely confidential, and most importantly, equips John and Sarah with the communication tools needed to successfully co-parent their children for the next decade. The alternative dispute resolution revolution proved that the legal system could adapt to prioritize psychological health and economic efficiency over institutional combat. However, as the 21st century dawned, a massive technological wave was preparing to hit the global landscape, introducing tools that would completely democratize access to legal data and challenge the monopoly of traditional law firms. The internet era was about to arrive, bringing with it a digital disruption that would turn the societal divorce journey into an automated, online, and completely decentralized experience. In the next part of this masterclass, we will examine the rise of the do-it-yourself online split, the emergence of algorithmic asset division platforms, and how the digitization of relationships created an entirely new set of cyber vulnerabilities that modern couples must navigate. The democratization of legal data via the internet systematically dismantled the informational monopoly that traditional law firms had maintained for more than a century. In the pre-internet era, the specific procedural mechanisms, local court forms, and statutory child support calculators were gatekept behind the heavy doors of law libraries or the billable walls of private practices. The average citizen had virtually no choice but to hire an expensive guide to navigate even the most mundane, uncontested legal filings. As the World Wide Web matured throughout the late 1990s and into the 2000s, state court systems began transitioning their administrative infrastructure online. This regulatory transparency paved the way for the rise of the pro se litigant, an individual who represents themselves in a legal proceeding without the assistance of an attorney. Software-as-a-service platforms emerged to capture this newly empowered consumer segment by offering automated document preparation. These platforms used intuitive, interview-style algorithms to collect user data, automatically populate highly specific state-level court documents, and provide step-by-step instructions on how to execute a legal separation independently. Historical trends show that within 2 decades, the percentage of family law cases involving at least one unrepresented party skyrocketed across nearly every jurisdiction in the United States, in some areas crossing the 70% threshold for simple, uncontested filings. This shift completely altered the operational workflow of family court clerks and judges, who were forced to adapt their daily operations to assist a massive influx of citizens unfamiliar with formal evidentiary rules and courtroom etiquette. To see how seamlessly this digital democratization functions in the current landscape of 2026, let us examine an everyday case study involving a couple named Brian and Jessica. Brian and Jessica have been married for 4 years, do not own real estate, have no children, and have mutually agreed to part ways. In an earlier era, even an uncontested split like theirs would have required physical appearances at a local courthouse, months of waiting for a court date, and significant financial expenditures on legal retainers. Today, Brian and Jessica log onto a state-approved electronic filing portal from their own laptops. The platform guides them through a comprehensive digital questionnaire, securely pulls their verified financial data directly from their banking applications via API integration, and populates a complete marital settlement agreement. They sign the final documents using encrypted digital signatures, verify their identities through an integrated remote electronic notary service, and submit the entire package directly to the court clerk with a single click. Within a few weeks, an algorithmic screening tool flags the submission as fully compliant with state guidelines, and a judge reviews and signs the final decree digitally during a scheduled window of administrative processing. For couples with minimal assets and total mutual agreement, the physical courtroom has been entirely replaced by a cloud-based automated pipeline, transforming a historically stressful bureaucratic ordeal into a streamlined, low-cost digital transaction. However, this technological convenience completely breaks down when the assets being divided are themselves entirely digital, abstract, and volatile. The massive explosion of the digital economy over the past 15 years has presented family law practitioners and forensic accountants with some of the most complex valuation challenges in the history of jurisprudence. Consider the emergence of decentralized digital currencies, cryptographic tokens, and virtual real estate. When a modern couple splits, the marital estate often contains highly complex portfolios of cryptocurrency, some of which may be stored in decentralized finance protocols or anonymous cold storage hardware wallets. Unlike traditional bank accounts, which can be easily audited with a standard judicial subpoena sent to a centralized financial institution, tracking down hidden cryptocurrency requires specialized digital forensics and blockchain analysis. If one spouse suspects the other is attempting to conceal marital wealth in digital assets, forensic experts must be brought in to analyze transaction histories on public ledgers, track transfers across various digital exchanges, and isolate hardware signatures. The immense volatility of these assets introduces severe legal friction. A cryptocurrency portfolio that is worth $200,000 on the day a petition is filed might crash to $50,000 by the time the final division order is executed, forcing judges to determine whether to value the asset at the date of separation or the date of the final trial. Even more challenging is the valuation and division of a monetized digital footprint, such as a popular YouTube channel, a highly profitable TikTok account, or a digital storefront operating on a global e-commerce platform. These modern digital properties are not just hobbies. They are high-earning businesses driven by intellectual property, algorithmically generated ad revenue, brand sponsorships, and recurring subscription models. If a couple built a successful digital brand together during their marriage, determining how to equitably divide that asset is a mathematical and legal nightmare. The court must separate the personal goodwill of the individual creator from the enterprise goodwill of the digital channel itself. If Jessica is the face of the online channel, the brand cannot easily function or generate revenue without her active, ongoing participation. Yet, Brian may have acted as the behind-the-scenes editor, producer, and business manager, directly contributing to the channel's commercial success. Forensic accountants must project the future earning potential of the channel's algorithmically driven revenue streams, apply a discount rate based on the inherent risk of digital platform policy changes, and determine a fair buyout structure. Potential outcomes in these scenarios often involve one spouse buying out the other's percentage of the estimated brand value, or the court ordering a structured, ongoing percentage split of the channel's future ad revenue, effectively keeping the divorced couple bound together as reluctant business partners long after their romantic relationship has ended. While technology has complicated asset valuation, it has completely revolutionized the collection of behavioral evidence through the weaponization of the digital footprint. Social media platforms, mobile text messaging applications, and cloud storage networks have transformed into the single most dominant source of evidence in modern family law courtrooms. Historical trends tracked by the American Academy of Matrimonial Lawyers reveal that an overwhelming majority of modern divorce attorneys utilize social media data as a primary tool to establish hidden assets, expose behavioral inconsistencies, and litigate custody disputes. Every single piece of content an individual uploads, comments on, or likes leaves an indelible electronic record that can be systematically archived and introduced in a court of law. Let us look at a precise operational example of how a digital footprint can completely destroy a litigant's legal strategy. Imagine a scenario where a spouse appears in court and claims under penalty of perjury that they are completely destitute, suffering from a severe career setback, and entirely unable to contribute to child support or maintain spousal maintenance payments. However, a routine electronic discovery sweep of their public digital footprint reveals a starkly different reality. Their LinkedIn profile boasts about a lucrative new consulting contract. Their Venmo public transaction history shows a steady stream of payments for high-end dining, premium sporting events, and weekend travel. And their geotagged Instagram stories place them at a luxury resort in the Caribbean during the exact week they claimed they were too ill to look for employment. Modern family lawyers do not just rely on public posts. They routinely secure court orders to conduct comprehensive mobile device forensics. This allows technicians to extract deleted text messages, review precise location data history from mapping applications, and download WhatsApp or Signal archives directly from physical smartphones. Metadata embedded within digital files can expose the exact date, time, and GPS coordinates where a specific photograph was taken, rendering attempts to falsify or manipulate timelines completely useless. The smartphone has effectively become an unblinking, digital private investigator that sits in a citizen's pocket, recording every transaction, communication, and location with absolute fidelity. This pervasive digital trail has forced modern couples to realize that privacy during a marital dissolution is a relic of the past, as their entire personal and financial lives are laid bare before forensic technicians, opposing counsel, and family court judges. The transition from physical paper trails to immutable cloud-based records has permanently altered the strategic playbook of family law, making digital literacy an absolute prerequisite for survival in the modern legal arena. Yet, as younger generations rely on automated tools and navigate these complex cyber landscapes to dissolve shorter partnerships, an entirely different, financially cataclysmic phenomenon is silently exploding across the older demographic of the United States. While the overall national divorce rate has experienced a stabilization, the rate of separation among couples over the age of 50 has experienced an unprecedented, staggering surge over the past 2 decades. In the next part of this masterclass, we will dive deep into the highly volatile world of gray divorce, analyzing the unique economic devastation that occurs when an estate is fractured at the finish line of a career, the complex division of mature retirement systems, and the hidden psychological toll it inflicts on adult children. The demographic shift known as gray divorce has fundamentally decoupled from historical national trends. While younger demographics across the United States are seeing a stabilization or steady decline in overall divorce rates due to delayed marriage, increased premarital screening, and shifting cohabitation patterns, the rate of separation for Americans over the age of 50 has experienced a staggering explosion. According to long-term demographic data compiled over recent decades, the divorce rate for individuals aged 50 and older doubled between 1990 and the mid-2010s, and for those over the age of 65, it tripled. This specific phenomenon is completely reshaping the family law landscape because the structural nature of a late-life split is fundamentally distinct from a separation involving a younger couple. When a couple in their late 20s or 30s divorces, the legal and emotional battle centers heavily on child custody schedules, parenting time allocations, and future career trajectories. In those younger scenarios, the primary economic asset available to both individuals is time. They possess decades of future workforce participation to rebuild their savings, recover from the immediate financial hit of a legal split, and benefit from long-term compound interest. In sharp contrast, a gray divorce occurs when the time horizon has completely collapsed. The couple is standing directly at the finish line of their professional careers, or has already transitioned into fixed-income retirement. They are forced to take a finite nest egg that was carefully calculated, invested, and structured to support a single shared household and slice it down the middle to fund 2 entirely separate independent lives. To analyze why this trend has surged so dramatically, we must look at the unique socio-economic catalysts driving this specific generational cohort. Americans are living significantly longer, healthier lives than any previous generation. An individual reaching the age of 60 today can reasonably expect to live another 2 or 3 decades in relatively good health. Consequently, when the final child leaves the home and the empty nest syndrome fully sets in, many couples look across the dinner table and realize they are facing 25 years of shared retirement with a partner from whom they have grown completely disconnected over decades of child-rearing and professional distraction. The cultural stigma that once acted as an institutional containment mechanism for bad marriages has entirely evaporated for this demographic. The pursuit of self-actualization, personal happiness, and emotional fulfillment is no longer viewed as a luxury reserved exclusively for the youth. Furthermore, women of the baby boom generation entered the competitive workforce in unprecedented numbers compared to their mothers, meaning a substantial portion of older women possess their own independent professional identities, baseline financial literacy, or a clear understanding of their legal right to claim an equitable portion of a massive marital estate, making the prospect of exiting a stagnant relationship practically viable. Let us examine a comprehensive case study to understand the exact economic mechanics of this late-life transition. Imagine a couple named Robert and Nancy navigating a family court proceeding in the current year 2026. Robert and Nancy are both 63 years old and have been married for 32 years. They have raised 2 children, both of whom are now independent adults with families of their own. Over more than 3 decades of marriage, Robert climbed the corporate ranks at a manufacturing firm, eventually reaching an executive level, while Nancy worked part-time as a medical administrator and managed the domestic sphere, ensuring the stability of the household. Together, they accumulated a seemingly robust marital estate valued at $1.2 million. This estate consists of a fully paid-off suburban primary residence valued at $450,000, a traditional 401k retirement account worth $500,000, a defined benefit corporate pension plan held in Robert's name, and various liquid savings and brokerage accounts totaling $250,000. In a single household, this portfolio represents a comfortable, highly secure retirement baseline. Split down the middle by a family court judge, it represents an immediate slide toward financial vulnerability for both individuals. The division of these mature assets requires highly specialized legal mechanisms that carry severe tax liabilities if executed incorrectly. Robert and Nancy cannot simply liquidate half the money from the 401k account and wire it to a new bank account because they are under the age of 59 and a half, or because standard withdrawals from traditional retirement accounts are treated as ordinary taxable income. Doing so would trigger massive early withdrawal penalties and catastrophic immediate income tax burdens that would instantly wipe out a third of the asset's value. To safely petition a qualified corporate retirement plan, the family court must issue a specialized legal document known as a Qualified Domestic Relations Order, commonly referred to as a QDRO. This document is not a standard boilerplate court order. It must be meticulously drafted by specialized legal technicians to comply simultaneously with both the Federal Employee Retirement Income Security Act and the highly rigid internal operating rules of the specific corporate plan administrator. The QDRO establishes the legal right of the non-employee spouse, Nancy, to receive a designated percentage of the retirement account as an alternate payee. Through this precise mechanism, the funds can be rolled over directly into an individual retirement account in Nancy's name without triggering a single penny of immediate tax penalty or income liability. Dividing Robert's defined benefit corporate pension plan introduces an even greater layer of actuarial and mathematical complexity. The court must typically choose between the shared payment method or the separate interest method to split the future monthly benefit checks. If they utilize the separate interest method, forensic accountants calculate the total present cash value of Nancy's portion based on her independent life expectancy, effectively slicing the pension into two separate, independent streams of income that Nancy can control and begin drawing upon according to her own retirement timeline. Beyond private corporate accounts, older divorcing couples must navigate the rigid federal regulations governing Social Security benefits. Under federal tax and labor guidelines, a divorced individual can claim a spousal Social Security benefit based on their former partner's earnings record rather than their own, provided the marriage lasted for a minimum of 10 consecutive years. The individual seeking the benefit remains currently unmarried, and they have reached at least age 62. This federal rule allows Nancy to claim up to 50% of Robert's full retirement age benefit amount without reducing Robert's own monthly check by a single dollar, offering a critical financial lifeline for former homemakers. However, if Nancy decides to remarry before reaching a specific age, that right is completely extinguished under federal law, creating a complex web of financial calculations that heavily influence late-life relationship choices and cohabitation decisions. The macroeconomic danger of a gray divorce is further exacerbated by the total elimination of the compounding time horizon, leaving the individuals highly exposed to sequence of returns risk. When Robert and Nancy divide their liquid accounts and sell the family home to split the equity, they hit the absolute worst phase of financial vulnerability. They are partitioning assets during a market cycle, where they have zero time to wait for an economic recovery. Each must now purchase or rent a separate residence in a highly competitive housing market, instantly doubling their basic monthly utility bills, property insurance premiums, and localized maintenance expenses. The $500,000 retirement account, when split into two $250,000 pools, can no longer generate enough sustainable passive income to cover these duplicated baseline living costs. Nancy is suddenly forced to explore re-entering the workforce at age 63 to cover her independent health insurance premiums, as she can no longer legally stay on Robert's corporate health insurance policy, and is still years away from qualifying for federal Medicare coverage at age 65. While the financial devastation of a late-life split is easily quantifiable on a balance sheet, the hidden relational and psychological toll of a gray divorce on adult children and grandchildren is frequently completely ignored by modern societal narratives. The cultural assumption dictates that because the children are grown adults with their own independent lives, careers, and households, they are immune to the emotional trauma of parental separation. Case studies reveal the exact opposite reality. Adult children experience a profound destabilization of their personal history, identity, and extended family structure. The family home, which served as the permanent anchor for holiday traditions, emotional security, and childhood memories, is sold off and liquidated. the structural mechanics of extended family gatherings become intensely strained and adversarial. Adult children are suddenly forced to navigate the complex logistical and emotional minefields of dividing holiday schedules, managing parental birthdays, and orchestrating major family events like weddings, baptisms, or graduations to ensure the divorced parents do not cross paths or trigger public confrontation. Furthermore, as these parents continue to age, the division of caregiving responsibilities becomes highly fractured. Instead of siblings coordinating to support an elderly couple living together in a centralized home, adult children find themselves managing two separate, geographically isolated households, effectively doubling the logistical caregiving burden and generating severe sibling friction over the allocation of time and financial resources. The Grey Divorce Revolution proved that no stage of human life is entirely insulated from the evolving structural forces of modern family law and economic fragmentation. The complex societal and relational architecture that Americans spend an entire lifetime building can be completely dismantled in a matter of months if the legal and financial mechanisms governing the late life split are not deeply understood. As the societal journey of the split reached this peak of late life complexity, a completely parallel transformation was quietly taking hold among the newest generation of American partners. This new cohort, observing decades of high-stakes legal warfare, financial volatility, and late-life domestic asset destruction, began executing a total philosophical retreat from the institution of traditional marriage altogether. In the next part of this masterclass, we will examine the modern rise of cohabitation agreements, the complex legal battles surrounding modern common law realities, and how a new generation is attempting to build relationships entirely outside the framework of state-sanctioned contracts. This rapid philosophical retreat from the institution of traditional marriage has triggered an unprecedented surge in non-marital cohabitation across the United States. Historical trends compiled over the last few decades reveal a profound demographic inversion. While traditional marriage rates have continually trended downward, the number of unmarried couple households has experienced massive growth. This behavioral shift is driven by a generation that witnessed the intense financial warfare, complex legal battles, and extensive asset destruction of their parents' divorces. To this new generation of romantic partners, bypassing the state-sanctioned marriage certificate feels like a rational, modern mechanism to insulate themselves from the reach of the family court system. By choosing to live together, share expenses, and raise children completely outside the bounds of a legal marriage, these couples believe they are retaining total autonomy over their personal lives and their independent financial assets. However, this widespread avoidance of traditional marriage has collided directly with a pervasive, highly dangerous cultural myth: the concept of common law marriage. Millions of unmarried Americans currently living with a significant other harbor the deep, completely incorrect belief that if they cohabit for a specific chronological period, typically rumored to be 7 consecutive years, the legal system automatically transforms their relationship into a valid common law marriage, granting them the exact same rights, property protections, and financial safety nets as a traditionally married couple. In the modern legal landscape of the year 2026, this assumption is a catastrophic misunderstanding of family jurisprudence. The overwhelming majority of United States jurisdictions have entirely abolished or heavily restricted common law marriage through explicit state statutes. Only a handful of states retain any framework for recognizing non-ceremonial marriages, and even in those specific regions, the law never operates automatically based on a simple timeline. To establish a valid common law marriage where it is still permitted, a couple must provide rigorous, clear evidence that they possessed a mutual intent to be married, continuously held themselves out to the public as husband and wife, filed joint federal tax returns, and shared a single domestic identity. For the millions of couples who do not meet these strict criteria, the law views them not as a family unit, but as two completely independent legal strangers who happen to share a physical address. This legal void means that when an unmarried, long-term cohabiting relationship breaks down, the separating partners do not have access to the specialized, protective infrastructure of the family court system. There is no automatic right to an equitable distribution of property, no statutory formula for spousal support, and no legal mechanism to look at the household as a shared economic partnership. Instead, the dissolution of their shared life is governed strictly by general property law, contract law, and traditional equitable remedies. To understand the severe financial vulnerability this creates, let us examine a profound historical case study that permanently redefined the legal rights of unmarried partners: the landmark 1976 California Supreme Court case of Marvin versus Marvin. This highly publicized dispute involved the famous actor Lee Marvin and his long-term partner, Michelle Triola Marvin. The couple lived together for 7 years without marrying, during which time Michelle legally changed her last name to Marvin, gave up her own independent career as a singer and entertainer, and devoted herself entirely to managing their households and providing companionship. When the relationship ended, Lee Marvin cut off all financial support and retained ownership of all assets accumulated during their time together. Because every single asset, property title, and bank account was held exclusively in his name, Michelle filed a historic lawsuit, arguing that the couple had entered into an oral agreement stipulating they would pool their earnings and share all property equally, and that she was entitled to ongoing financial maintenance based on her domestic contributions. The California Supreme Court issued a revolutionary ruling, holding that oral or implied contracts between non-marital cohabitants concerning the distribution of property are legally enforceable, provided those agreements are not explicitly based on the exchange of sexual services. This ruling introduced the cultural term palimony to the American lexicon. The court declared that in the absence of an express written or oral contract, judges could look at the actual behavior and conduct of the parties to infer an implied contract, or deploy equitable doctrines like quantum merit to compensate a non-titled partner for the reasonable value of their domestic services to prevent the unjust enrichment of the higher-earning individual. While the Marvin case study opened a critical pathway for unmarried litigants to seek financial justice, its practical implementation across the United States remains incredibly fragmented. Many states, such as Illinois, completely rejected the Marvin doctrine, ruling that enforcing relationship-based contracts for unmarried couples violates public policy by actively denigrating the status of traditional marriage. Even in states that accept the doctrine, proving the existence of an oral or implied contract requires an immensely expensive, prolonged civil court trial, forcing litigants to rely on vague personal memories, old emails, and circumstantial evidence to establish a legal right to support. Let us look at a contemporary scenario to see how this legal fragmentation operates in daily life today. Imagine a situation involving an unmarried couple named Brandon and Chloe. Brandon works as a high-earning corporate consultant, while Chloe steps away from her professional career path for 8 years to manage their home, coordinate a massive renovation on a property titled exclusively in Brandon's name, and raise their 2 young children. Because they are not married, Chloe assumes that their long-term commitment and shared domestic life mean they are building a collective future. If they decide to separate, potential outcomes for Chloe are economically devastating. When a married couple divorces, the family court judge immediately looks past the legal titles on deeds and bank accounts, treating all wealth acquired during the marriage as joint marital property subject to an equitable split. Furthermore, the judge would assess Chloe's lost career advancement and potentially award her robust spousal support to ensure her economic rehabilitation. But because Brandon and Chloe are unmarried, the family court possesses zero jurisdiction over their property division. Brandon walks away with the renovated home, his corporate retirement accounts, and his full earning capacity completely intact, because they sit entirely under his independent legal title. Chloe cannot claim standard alimony under family law statutes, while Brandon remains strictly obligated to pay child support based on the automated state mathematical guidelines discussed in earlier segments. That child support is calculated to cover only the baseline costs of the children's clothing, food, and education. It does not provide a single dollar to support Chloe's independent housing, health insurance, or long-term retirement security. Chloe is suddenly forced to re-enter a highly competitive workforce with a massive 8-year resume gap, facing a downward economic trajectory simply because she invested her labor into a relationship that lacked a formal state contract. To insulate themselves from these catastrophic potential outcomes, a growing number of modern cohabiting couples are turning to the strategic deployment of a specialized legal instrument, the cohabitation agreement. A cohabitation agreement functions essentially as a customized, highly detailed corporate partnership contract for a domestic relationship. It allows an unmarried couple to explicitly define the financial rules governing their shared life, bypassing the uncertainty of state property laws entirely. A comprehensive cohabitation agreement explicitly itemizes every single asset and debt each individual brings into the relationship, establishes precise protocols for how daily household living expenses and mortgage payments will be allocated, and clearly delineates which property will remain strictly separate and which will be treated as jointly owned. Furthermore, the contract can outline an explicit exit strategy, detailing exactly how the equity in a shared home will be appraised and divided if a split occurs, and stating whether any voluntary, Structured financial support will be paid to a lower-earning partner to compensate for domestic sacrifices. By putting these terms into a legally binding written contract, signed voluntarily after a full disclosure of finances, and with the assistance of independent legal counsel, couples can achieve total economic predictability without ever stepping foot inside a traditional family court. Beyond managing the internal dynamics of an unmarried split, the legal definition of cohabitation has simultaneously transformed the financial landscape of post-divorce life for individuals who have already exited a prior marriage. Across the United States, standard divorce decrees and state family law codes historically dictated that a paying spouse's obligation to provide alimony or spousal maintenance would automatically terminate upon the death of either party or the formal remarriage of the receiving spouse. To avoid losing these critical monthly support checks, many divorced individuals chose to move in with a new romantic partner while intentionally avoiding a formal wedding ceremony, allowing them to enjoy the benefits of a shared household while continuing to collect alimony from their former spouse. This practice triggered a massive legislative and judicial counterassault, leading to the creation of modern cohabitation modification statutes. Today, if a paying spouse suspects their former partner is living with a new significant other, they can petition the court to significantly reduce or entirely terminate their ongoing alimony obligation based on changed circumstances. Let us look at the exact step-by-step legal standard established in recent landmark case studies, such as the New Jersey Supreme Court case of Cardali versus Cardali. The law dictates that a romantic relationship does not need to be marital or permanent to trigger a support termination. It must simply exhibit stability, permanency, and mutual economic interdependence. To secure the right to audit a former spouse's private life, the paying partner must first establish a prima facie case of cohabitation. This threshold requirement has turned family law into a high-tech surveillance operation. Paying spouses routinely hire private investigators to conduct extensive physical surveillance over months, documenting that a new partner's vehicle is parked at the residence every single night, that the partner possesses a key to the home, and that they participate in routine domestic chores like retrieving the mail, mowing the lawn, or purchasing groceries. This physical surveillance is paired with digital forensics, tracking social media check-ins, public Venmo transactions showing shared utility payments, and shared vacation photos. Once this threshold is met, the court unlocks the discovery process, forcing the cohabiting couple to hand over private bank statements, credit card records, and lease agreements to determine if their finances are intertwined. The societal journey of the split has effectively evolved to a point where even choosing not to marry no longer insulates an individual from the extensive financial audits and tracking mechanisms of family law jurisprudence. The intersection of digital tracking, non-marital legal frameworks, and changing demographic values has officially pushed the American relationship journey into uncharted territory. Unmarried partners must now navigate a landscape where their domestic choices carry immense, high-stakes legal consequences that mimic corporate liabilities. As society stands in the year 2026, observing a century of total transformation that systematically dismantled fault doctrines, automated child support formulas, expanded property definitions, and elevated alternative dispute resolution, we are forced to look directly at the cutting edge of what lies ahead. The ultimate transformation of the human split is no longer just about changing laws or demographic shifts. It is about a total technological assimilation that threatens to automate the entire judicial process itself. In the final, concluding part of this Masterclass Master Series, we will examine the absolute frontier of family law, the rise of artificial intelligence judges, predictive analytics in settlement negotiations, and the definitive verdict on how a century of radical change has permanently transformed the way Americans love, part ways, and protect their futures. The incorporation of artificial intelligence and machine learning into family law practices represents the absolute frontier of this century-long evolution, transforming the operational baseline of domestic relations across the United States. In the current landscape of the year 2026, specialized platforms like CoCounsel Legal, Splitify, and Aparty AI have systematically replaced traditional manual discovery with automated data parsing engines that analyze raw, unstructured information at a scale previously unimaginable. Imagine a modern family law firm where paralegals and junior associates no longer spend entire weeks manually reviewing massive document dumps consisting of decades of personal text streams, financial spreadsheets, bank statements, and child protective services reports. Instead, professional-grade artificial intelligence assistants ingest thousands of pages simultaneously, utilizing advanced natural language processing to isolate relevant evidence with pinpoint precision. These intelligent systems are engineered to instantly flag hidden financial irregularities, map out domestic violence timelines, detect patterns of parenting time interference, and automatically populate highly complex state-level court documents, such as California family law financial disclosure forms, directly from a client's initial digital questionnaire. By removing the immense administrative drag that has historically plagued family courts, technology is shifting the velocity of the split, turning a process defined by chaotic human triage into a highly automated, data-driven pipeline. Plus one, this technological transformation extends far beyond administrative efficiency, manifesting as an entirely new methodology known as predictive analytics for law firms. Historically, navigating a domestic dispute was treated as an intuitive, highly subjective art form where legal strategy relied heavily on the personal experience of an attorney and their localized familiarity with individual jurists. Legal practitioners frequently operated under the traditional maxim that a good lawyer knows the law, but a great lawyer knows the judge. Today, advanced predictive models offered by platforms such as Lex Machina, Docket Alarm, and Westlaw Edge have completely inverted this dynamic by analyzing massive historical datasets encompassing millions of court filings, judicial decisions, and localized case resolutions. When an individual initiates a separation, machine learning algorithms evaluate dozens of distinct variables, including precise income metrics, asset classifications, regional statutory frameworks, and historical judicial patterns, to simulate hundreds of potential outcomes. These systems can forecast the exact mathematical probability of prevailing on a specific temporary custody motion, or estimate the precise numerical range of a likely spousal support award with documented accuracy. This transition from subjective human intuition to empirical statistical modeling allows family law professionals to manage client expectations with unprecedented confidence, changing how legal risk is evaluated before a single motion is ever filed in open court. Plus two, to observe how this empirical calculation dictates modern reality, let us examine an imaginative scenario involving a professional couple named Eric and Melissa navigating a high-asset corporate dissolution. Eric works as a senior executive at a major technology conglomerate, holding a highly complex compensation package consisting of unvested restricted stock units, performance bonuses, and deferred corporate retirement accounts. Melissa operates as the founder and primary shareholder of a rapidly expanding global e-commerce storefront. Their combined marital estate is heavily intertwined with intangible digital assets, algorithmically driven revenue streams, and complex intellectual property structures. Instead of embarking on a traditional, multi-year adversarial litigation track that would inevitably consume hundreds of thousands of dollars in billable hours and publicly expose their corporate operations, their respective legal counselors utilize an advanced predictive settlement platform. The software securely ingests their verified financial history via secure API connections, references historical trends from identical corporate asset splits within their exact judicial circuit, and deploys a comprehensive what-if simulator. The lawyers can dynamically adjust specific variables, such as shifting the physical custody schedule by a handful of overnight stays to cross statutory thresholds or restructuring the long-term payout timeline of the e-commerce business valuation, and instantly preview how a local family court judge would likely rule on that exact configuration. Faced with the cold, unyielding mathematical probabilities generated by the algorithm, the emotional bravado and strategic posturing of both parties evaporate, facilitating a rapid, evidence-based settlement that reduces interpersonal conflict by half. Yet, this rapid surrender to algorithmic justice introduces a deeply volatile set of cyber vulnerabilities and ethical dilemmas that the modern legal establishment is struggling to regulate. The unprecedented accessibility of advanced generative technology has fueled a surge in the weaponization of deepfakes and fabricated digital evidence within custody and asset disputes. Disgruntled partners can now easily access sophisticated software to clone a spouse's voice, generating highly realistic audio clips of threats or admissions of neglect, or manipulate pixel structures within mobile messaging screenshots to manufacture fraudulent evidence of parental unfitness. To defend the integrity of the judicial process, family law practices are forced to deploy specialized forensic scanners like DeepWare or PinDrop to analyze file metadata, detect microaudio anomalies, and audit blockchain transaction logs to validate the authenticity of digital footprints before they are introduced into a record. Furthermore, prominent legal scholars warn that these predictive models are inherently backward-looking engines that run the severe risk of permanently automating historical institutional biases. A landmark data science study conducted by researchers at the University of New South Wales analyzed over 2,500 custody judgments across thousands of documents, exposing deep systemic gender biases embedded within historical legal language. The algorithms revealed that mothers were consistently evaluated based on traditional, rigid caregiving expectations, whereas fathers frequently received disproportionate judicial praise for minimal parental involvement or had their caregiving capacity artificially inflated by the assumed labor of a new female partner. If modern artificial intelligence platforms simply scrape these biased historical precedents to recommend current custody splits, the technology risks codifying past societal inequities under the guise of objective mathematical neutrality. +1. This convergence of digital tracking, automated forecasting, and shifting human values brings us to the definitive verdict on this extraordinary century of change. The societal journey of the American split has completed a total philosophical and operational cycle, traveling from an era of strict institutional containment to a landscape of hyper-individualized, automated optimization. In the early decades of the 20th century, the state functioned as a rigid moral gatekeeper, viewing marriage as an indissoluble covenant and forcing unhappy couples into a toxic, humiliating theater of fabricated adultery and systemic perjury, just to secure their legal freedom. The no-fault revolution of the 1970s permanently shattered those institutional barriers, reconceptualizing marriage as a voluntary, soulmate-driven partnership that could be terminated at will by the expressive desire of a single individual. However, that sudden liberation exposed severe structural economic vulnerabilities, forcing the federal government and state legislatures to engineer the automated child support enforcement complexes, the rigid income shares mathematical formulas, the expansive definitions of intangible property, and the complex prenuptial protections that govern contemporary wealth. Today, the physical courtroom has been systematically bypassed, replaced by private mediation suites, collaborative multidisciplinary team conferences, and cloud-based online portals where a family unit can be entirely dismantled with a series of encrypted digital signatures. However, as the mechanics of ending a relationship become increasingly streamlined, professionalized, and calculated, modern society is forced to confront a profound, lingering question regarding the true human cost of this absolute efficiency. By transforming the dissolution of a household into a seamless administrative transaction or a predictive mathematical formula, the legal system has successfully stripped away the archaic punishments, the public shaming, and the systemic delays of the past. Yet, in doing so, it has simultaneously risked removing the vital human empathy, the personalized judicial oversight, and the emotional closure required to successfully heal a fractured family. The modern citizen operates in a landscape where domestic partnerships are increasingly calculated as financial investments, where cohabitation agreements function like corporate bylaws, and where predictive algorithms dictate the precise monetary value of parenting time. We have achieved mastery over the operational math of parting ways, but in doing so, we have turned the conclusion of a shared human life into a cold, hyper-rational optimization problem. This total digitization and rationalization of the domestic sphere has not eliminated the fundamental volatility of human relationships. It has simply accelerated the migration of personal conflict into an entirely new, uncharted global arena. As younger generations observe the total corporate professionalization of the domestic contract within the United States, they are no longer just retreating from traditional marriage or drafting localized cohabitation agreements. They are actively utilizing international remote work infrastructure, global asset havens, and decentralized jurisdictional frameworks to construct relationships that completely bypass individual state sovereignty altogether. This global dispersion of personal partnerships is quietly generating an unprecedented international constitutional crisis that family law systems are completely unprepared to regulate. In the next phase of this exploration, we will step directly across national boundaries to analyze the hidden world of international jurisdiction clashes, the rising phenomenon of cross-border asset shielding in a completely remote global economy, and the highly sophisticated legal playbooks deployed by the modern digital nomad to protect their wealth and their legacy against the upcoming global realignment of family law.